Yes. Welcome to today's series on the law of evidence, part 1. My name is Obo Peter Kanu. In this lesson, we'll be considering the meaning and scope of judicial evidence. Before we go into the meaning of judicial evidence, let me make one preliminary point here, and that is that the law of evidence is without doubt and exaggeration one of the most important law subjects. This is so because in the conduct and determination of cases in court, the rules and principles of evidence play a chief role in determining which facts are admissible and the legal means of attempting to prove or establish such facts. Having said that, we can now attempt to answer the question, what is judicial evidence? In other words, we may now proceed to consider the meaning of evidence. In considering the meaning of evidence, it is instructive to note that there is no generally acceptable and satisfactory definition of evidence. Rather, what we have are various attempts by scholars, authors, and jurists to define evidence. This is so because it is practically impossible to have an exhaustive and conclusive definition of evidence, one which captures the entire essence of evidence. So in this lesson, we will be looking at the various definitions of evidence given by scholars such as Professor Phipson, Professor Cross, Professor Noakes, Professor T.A. Aguda, and our own very distinguished Oputa JSC in the case of Akintola and Anoda and Solomon. According to Professor Phipson, evidence is the testimony, whether oral, documentary, or real, which may be legally received in order to prove or disprove some facts in dispute. I take that again. Professor Phipson defines evidence as the testimony, whether oral, documentary, or real, which may be legally received in order to prove or disprove some facts in dispute. For Professor Cross, he sees evidence as the testimony, hearsay, documents, things, and facts which a court will accept as evidence of the facts in issue in a given case. Professor Noakes, on the other hand, defines judicial evidence as evidence received by courts of justice in proof or disproof of facts, the existence of which comes to question before them. Our own Nigerian scholar, Aguda T.A., adopted an explanatory approach in defining evidence. For him, judicial evidence is the means by which facts are proved, but excluding inferences and arguments. He went further to say that it is common knowledge that a fact can be proved by the oral testimony of persons who perceived the fact, or by the production of documents, or by the inspection of things and places. All these come within the meaning of judicial evidence. The learned author went further to say that, on a very broad view, it is sometimes permissible to include in this list such other means of proving a fact as admissions, judicial notice, presumptions, and estoppels. The Supreme Court, per Oputa JSC in Akintola and Anoda and Solomon, made a worldwide judicial attempt to define evidence when it held that if a thing is evident, it requires no evidence. What therefore is evidence? Simply put, it is the means by which any matter of fact, the truth of which is submitted to investigation, may be established or disproved. Evidence is therefore necessary to prove or disprove an issue of fact. Now, despite the variations in the various definitions of evidence, as we just stated, there however appear to be some striking similarities between them. For instance, these various definitions all agree that evidence is a testimony. 2. They also are in agreement that evidence could take various forms, such as oral, documentary, or real, etc. They are also in agreement that for any fact or set of facts to qualify as evidence, such fact or set of facts must be legally receivable or acceptable. And finally, the various definitions of evidence all agree that evidence is admissible or receivable to prove or disprove facts or facts in issue in a given trial proceedings. Now, as correct as all these definitions are or may seem, none of them can be said to have conclusively and exhaustively captured the meaning of evidence. This led Professor Fidelis Nwadialo to maintain that it is more beneficial to seek to establish the scope of the subject than attempting its meaning. Conclusively, since there is no generally acceptable and satisfactory definition of evidence, a working definition of the subject evidence may be adopted in this lesson as follows: that evidence is a means by which facts in issue or relevant facts in any judicial trial or proceeding may be established or disproved. This could either be oral, which is the testimony of persons who perceived the facts in issue or relevant facts, or documentary, which is the production of documents for the purpose of proving fact in issue or relevant fact, or real, which is the production of material objects other than documents for the inspection of the court. Evidence is therefore the fulcrum of every judicial trial, and as such, no trial, I repeat, no trial can thrive without evidence, whether it is to prove or disprove facts in issue in any such trial. Now, having discussed the meaning of evidence, we may then proceed to examine the scope of judicial evidence. Now, when we talk about the scope of judicial evidence, or when we talk about the scope of the law of evidence, what we are simply saying is that we are referring to the depth, extent, or coverage of the law of evidence. In other words, whenever the question, what is the scope of evidence, is put forward, what is simply asked is that what is the depth, extent, or coverage of the law of evidence. This was provided for by Professor Noakes. Now, according to Professor Noakes, the scope of the law of evidence consists of two things, namely A. Facts which are legally admissible, and B. The legal means of attempting to prove such fact. Professor Fidelis Nwadialo, our Nigerian scholar, was in concurrence with Professor Noakes on this matter. Now, from the foregoing, therefore, one would rightly say that the law of evidence is within the adjectival, that is the procedural law, and thus anything outside this exceeds the scope of the law of evidence. Now, in concluding this lesson on the meaning and scope of evidence, it is instructive to point out here that the rules of evidence were formulated to assist in the determination of four cardinal problems or questions of law, namely A. Upon whom rests the burden of proving facts. B. What facts must be proved. C. What facts ought to be excluded from court's cognizance. And D. Which modes of proof are acceptable. I repeat, the rules of evidence were formulated to address or determine four cardinal problems or questions of law. These are A. Upon whom rests the burden of proving facts. B. What facts must be proved. C. What facts ought to be excluded from court's cognizance. And D. Which modes of proof are acceptable. Now we have come to the end of this lesson. In our next lesson, we will be discussing the various classifications of judicial evidence. And I'm sure you benefited from this lesson and will join us in the next lesson. Please, just subscribe to the channel for the next lesson. Thank you. See you in the next lesson. Stay tuned. As you watch this video, there is a subscribe button below the video. Click on the subscribe button and you will get more access to videos on other lessons. Thank you. Stay tuned until we meet again in the next lesson. God bless you.